on 28th.
For suspension of sentence.
Mal.
Objections filed.
Objection not yet been filed, but since the last 1 year is pending.
Okay, when do you want?
28 Miller.
Next Wednesday?
Yes.
Okay.
Obliged.
May please, your Lord. No, I have also not similar types of prayer methods something for application. So maybe on
Objections-
29, ma'am.
Objections filed.
Yes, ma'am.
Okay, 29.
29.
Sure. I also beg to cancel listing of IA in criminal appeal C60 of 20. But
Yes.
objection has been filed.
What do you want? Listing?
Yes, sir.
Okay, next Friday. Not this Friday, next Friday.
Deeply okay. May I similar prayer next Friday.
May I please, your Lordship? Lordship, I beg to mention item number 3 of today's list.
Yes.
Lordship, with the consent of the appellant side, I created a maternal password for the day, Lord. Due to some
19
personal.
matter, okay. Other side informed.
Yes, he's there.
19 matter, don't take much time. We'll
Lordship,
fix it
Lordship.
after 2
Password for the day, Lord.
Okay. On a request made on behalf of the respondent number,
All the respondents, Lord.
all the respondents.
State is there. State is
This
there.
is against acquittal.
Yes.
On the request, the matter is adjourned to be listed after a week. Yes.
May I please, Lord? Lordship, I beg to mention item number 7, Lordship, for today, Lordship.
Hmm.
7, Lordship. Only password for today, Lordship. Typical.
You're for the petitioner,
Here, appellant, Lordship.
appellant. Have you informed the amicus? Respondent number 2, Dipanjali Borpujari is there. You have to inform her.
You inform, Lordship.
No. You inform first. We don't allow mention without informing first. We will not do. You say, I have informed. Come after informing, then only. Not now. Yes, Mr. Bora?
May I please, Your Lord? Topic mention item number 8, my lord.
Eight,
Second concern for the matter study matter. Can be after 2 weeks, my lord. Next week, we have fixed another matter for it.
Well, what is the difficulty today?
We need some time, my. Next week, another hearing is fixed.
Next week, the hearing is there. Is there a ground?
Can it be on, my lord? Can it be on 9th,
No,
my
we'll
lord?
adjourn the matter, but that's not a ground. You have to, we don't adjourn for asking. On a prayer made on behalf of the appellant, list after a week. Yes.
Problem.
May please, your Lordship. Your Lordship, I beg to mention item number 8. You have taken consent from
8
the
has been mentioned.
my Lord, 1, your Lord. Item number 1.
1.
I apologize.
Yes.
In this matter, your Lordship, there is a substantial question of law relating to Mohammedan law. So we need some time to prepare this matter. Your
17 matter.
Yes, sir.
Why?
Some time is required to prepare this matter. 2 weeks
What
time.
substantial question? This is a matrimonial appeal.
Yes, my Lord. I understand.
Where is the question of a substantial question of law involved? Who is for the other side, informed or not?
He has been.
17 matter, don't ask for adjournment. It's very embarrassing. If there is a substantial question of law, you should have given importance.
My Lord.
Okay, next week. A request made on behalf of the appellant. Matter is adjourned to be listed after a week.
Obliged.
Yes,
Dear
Madam
Lord.
Borpujari, there is some mention.
Only
You are not around to be informed. Item number
7, Lordship. 7.
7. On a request made on behalf of the appellant, matter is adjourned to be listed after 2 weeks. Ms. H. Jahan Leonard, why 2 weeks? Ms. H. Jahan Leonard, APP, and Ms. D. Borpujari Leonard, counsel for respondent number 2, as legal aid counsel
Yes.
are present.
Deeply obliged.
May please, your Lord. Lordship, I beg to mention for listing of an IF for condonation of delay of 6 days, Lordship.
First time.
First time.
Okay, whenever. Monday.
And another prayer, Lordship, for IA for suspension of sentence.
Pending matter.
Lordship, pending matter.
Okay, next Friday.
Next. Deeply obliged.
Okay, we'll have some, there are part-heard matters. One of Mr. Sharma and one part-heard yesterday's.
Lordship, this item number 2, Lordship.
Yes,
Lordship, in this matter may be, Lordship, because there's no public prosecutor for the state here, Lordship. The permission was also granted to move this matter here as citizen bench was not available there.
Okay, only for that reason.
Lordship.
Okay, well, then we'll send it back.
Lordship.
Okay. There is no difficulty otherwise to be taken.
Yes,
Lord.
my lord.
No other grounds like of some threat perception, all those,
No, no,
nothing else.
nothing is,
Okay. Heard Sri S.K. Deori, learned counsel for the appellant, and Sri Arun
Chandran,
Chandran, you are
senior government.
senior advocate AP. Para. The learned counsel has jointly submitted that the appeal was moved in the principal bench as at that relevant time there was no division bench at the in the Itanagar at Itanagar. Full stop. However, the division bench being available now, both the learned counsel has submitted that the matter may be transmitted to the Itanagar bench. The state council has also informed that there is no PP presently for the state of Arunachal Pradesh in the principal bench. Full stop. Para. Considering the above, the registry is directed to transmit to take steps for transmission of the case records to the Itanagar bench.
Apply that.
And thereafter list this matter for hearing in that bench. I think Madam Bhuya asked for some accommodation. Where is Mr. Sharma? R. Sharma? No, where is R. Sharma? Will take up his case. Is it listed today?
Yes.
R. Sharma, we had said he'll take up his case today. Who will be operating? Madam, you'll be No, not in her case. The R. Sharma's case. You have the records. Madam Sharma, you have otherwise finished, completed. Okay. Yes, madam, where is your senior? Where is your senior?
Personal matter.
Okay.
Busy. So
Now we'll accommodate her. Kindly
Right.
try to locate Mr. R. Sharma. We can start off with the other matter. R. Sharma file today. It was R. Sharma. Madam Sharma, wait for a while. No, I don't. Good, good. I get Chaudhary. Yes, Madam Chaudhary, which matter is yours? Yes, Sharma has. Which matter is yours otherwise?
Item 11.
Criminal appeal. Criminal
Madam-
appeal. Matrimonial appeal.
Yes, madam.
You are the respondent.
I am for respondent.
My lord, I am for the evidence.
Okay, no, this, we have two partnered matters, and one matter we have fixed. You come after some time, maybe around 12 o'clock you.
Yes.
Yes.
What is the matter?
My lord, matter is regarding the divorce, my lord.
No, that we understand. You are the husband.
Yes, my lord.
Husband is aggrieved by what?
Agreed by.
Non-grant of divorce?
Yes, my lord.
Okay, your grounds of divorce was what?
My lord, they are living separately since the year 2013, my lord.
No, what were the grounds?
Ground is cruelty and desertion by the wife, my lord.
Cruelty and desertion.
Yes, my lord.
Both the grounds negated.
Yes, my lord. The evidence or deposition of the appellant and his mother has not at all been considered by the
Okay.
Garnet court.
Okay, we'll consider. Okay.
Obliged, my lord.
Okay, you come after some time,
Yes, my lord.
not before 12 o'clock.
Yes.
Okay, Sharma. Huh? Want to Pathas. Pathat to Heri Naina, Bhuya Naina. Oh, even other side is not there. Oh,
Item 5 is also,
No, yesterday's matter, which,
that is 12, that is also.
that will start. You be here? Okay. You got the paper book? Oh. You can start, gradually you can start. Because the other matter of Mr. Sharma, she has already completed, so now he can start, I think. Some paper book, what is, right. Just 2 minutes. You're amicus?
Yes.
Bora would be appearing. We record whose name? We are also reading the paper book for the first time. You also read for the first time.
Yes. I'll go.
But we suppose that you are not reading for the first time. We hope you have read a number of times. You cannot afford to have that luxury without preparation. Okay.
Means. But the accused here has been convicted on the 302 for life. If I may just give us this, the story of the prosecution is that the accused was residing with his brother.
The informant is PW2.
Yes, he is also the brother of the accused as well as the victim. He is one of the
Brother killing brother.
brothers. So these two brothers, the story of the prosecution is that they used to stay together in the trustee house of the tea garden. And on the morning when the son of the victim came, he saw the dead body
Of his
And-
father.
of his father. And on the basis of circumstantial evidence, because he was presumed to be with him during the night, ultimately there was something, because there was no eye. But
What is the nature of the injuries?
injuries they have given, they we just read out the doctors then. There was a bit of X, he was
Sharp weapon.
sharp. But I would try to impress upon your thought that his presence is doubtful. So there are gaps in the circumstances, and on the basis of that, he cannot be convicted because there are two hypotheses possible. When it is
Oh, last seen theory has been applied.
last seen theory, they have gone on the circumstances, circumstantial evidence as this. He was there, it was onus on him to explain.
106.
Yes, one. So that was the,
But last seen theory has been applied or not?
it's not been applied as such in the judgment.
And what about the motive?
Motive, they have said the motive is not necessary because
No, was there any motive which was established in
No.
the proceedings?
No. there must have been some quarrel or wrong that has not come up. They were staying together, there must have been fight for which the onus was on him to explain. But then his presence has to be established beyond reasonable doubt. So I'll just try to satisfy whether
Okay, you come.
I'll come to the FIR first.
Yes, please.
FIR page 1 of the paper book. It was lodged on 30/10/2018 under section 302. Occurrence is 29/10/2018, the previous at 9 p.m. And the information received is on the morning, next day, 30th.
Bhavananda is the brother of the deceased.
Yes.
As well as brother of the appellant.
Yes. Page 4, if I may read.
Keshav Tanti. The deceased is Keshav Tanti.
Yes. The informant father's name and the accused father's name. If I may just read this.
Yes, yes. Please read.
Humble submission is that around 9 p.m. on 29/10, in course of a quarrel over some domestic matters, the aforementioned accused person attacked my younger brother Keshav Tanti, who live in the same line, inside his quarters with an axe. As a result of which, Keshav Tanti sustained grievous injury on his head and died instantly. I therefore pray for you to take necessary action against the accused outside. He was under trial,
Okay.
page 7.
It was, the information was lost at 11 a.m.
Yes.
Next day, on
Next
30.
On the morning, they all came to know the commission of the
Okay. Yes.
PW1 is a
How many PWs?
witness is around 12.
12.
The son witness would be a bit material.
One charge.
No, no, 11.
No, one charge.
One charge.
302. Yes, please.
PW1 is the father.
Page 8.
Yes.
No, not.
No, not father. His father is the Dasarath Tanti. He's the same.
No, he is the mother.
Lakshmi Tanti is the mother and husband
Mother.
name is Lakshmi Tanti. Dasarath Tanti.
She is the mother of the deceased
This
as
is
well as the appellant.
Complainant and the
Yes.
accused Arun Tanti is my son. The informant is also my son. About 8 months ago, my son Arun Tanti killed his elder brother Keshav Tanti following a quarrel. At that time, I was in informant Bhavananda Tanti's house.
Don't say Tanti, it's Tati.
Tati. Arun and Keshav stayed in the company's house. I was at the Bhavananda's house, the complainant's house, which is at a little distance. The incident took place at night. Around 8-9 a.m. on the following day, my grandson Viras Tati went there and said that his father has been killed and that he did not know as to who had killed his father. Going there, I saw that Keshav had already died. There was injury in his neck caused with an axe, and there were injuries in different parts of Keshav's dead body. The dead body was lying outside the quarter.
This
So-
quarter belongs to whom?
As per this witness statement, Arun and Keshav stayed together.
Where?
Arun is the accused, Keshav is the victim.
Okay, in the cross-examination, the first line.
Yes.
They stayed together.
Stayed together. But there are other contrary evidence and the statement of the accused group.
What was the age of the victim?
It is
Look into the PM.
Around 40 years. That is at page 70. The cross examination. Yes. Arun cross examination. The Arun and Keshav live together in Pakka house. Keshav's sons Viraj and Tati also live with them. The houses of Rajesh Orang and Mahikanta Tati are situated nearby. I do not know at what time Keshav died. I also do not know who killed him and how. At the time of the incident, Viraj was not present at the home, the son of the victim. He had gone to watch TV and slept there at night. He was killed with an axe of their house. On seeing blood on the axe, he said that Arun had killed Keshav. He did not witness the incident, the grandson Viraj. The house of Mahikanta is adjacent to that of Keshav. Mahikanta lived with his family and there are 4 members in his family. On entering the house, I saw Keshav lying on the ground of the first room. The door was open. It is not a fact that I did not state before police that I saw blood oozing out of Keshav's neck. It is not a fact that I have adduced evidence against the accused as tutored by the evidence. Only thing, Your Lordship, that has come out is that the accused and the victim stay together. And Viraj usually stays with his father, but that night he was with the complainants and his grandmother's house. But this statement, Keshav's sons Viraj also live with them. I will show it contradicts with PW2.
Yes.
PW2
Grandson is a major, examined.
Yes, he's been examined as PWD 3. At the time of his deposition, his age was 14.
14.
Minor.
Okay, minor.
PW2 is the complainant. Accused Arun Tanti is my younger brother.
Informant.
Yes, I am the informant. The incident took place about 7-8 months ago. My mother and I lived in Kacha house. Both Arun and Keshav are my brothers. They live in the Pakka house. They live about 200 meters away from us. My younger sister Nirasi Tati came to our house. While I was going to my brother-in-law's house at Tangla to leave my sister there, one of my neighbors informed me over phone about the incident that Arun Tanti had killed Keshav. Then I came back. I reached home at around 9:30 a.m. I saw Keshav lying dead. Arun said that he killed Keshav by assaulting him with an axe. This is an extrajudicial confession, but it is in the presence of police. It will come out. The police had already come before they had arrived. Arun and Keshav engaged in quarreling after consuming liquor. On the previous night, an incident of assault took place. I saw cut injury in Keshav's neck. Police came. Police brought the dead body to Bihali for post-report examination. Police questioned me. Keshav Tati left 2 sons, Siraj and Viraj, about 10 and 8 years. Thereafter, I lodged an Ejahar. Exhibit 1 is the Ejahar lodged by me. Exhibit 1-1 is my signature. Police.
Arun was also a bachelor or he was married? The appellant?
That is no.
The deceased had 2 sons.
This is
One was the Biraj,
Viraj.
who had given the first information.
Yes.
Okay.
First information is by
No, information to the
family.
PW1, to the PW1.
Yes.
He said that grandson had gone to their place, noticed and informed us.
Yes.
PW to the informant says that he was going to leave
Leave
his
his-
sister. He got a telephone call, then he came.
yeah.
And there was an extrajudicial confession made before him.
If a hue and cry is raised at the Pakka house, it is not audible from our house. Keshav Tanti's elder son Biraj,
There was something that regarding the distance, his house,
distance is 200 meters,
200 meters.
the previous stage.
Okay, yes.
So,
200 meter, it may not be audible.
yeah, yeah. But those kind of houses has two parts. That other witness they were talking about, Mahikanta, is the one who lives in the other parts. He also didn't hear any hue and cry. But that
No,
is
just imagine 200 meters is,
otherwise
is not a very less distance. 200 is some distance,
Yes.
so some shouting may not be audible,
audible.
may not be.
Because one is Pakka house, one is Kacha house.
Mm.
Here, your the second line, Keshav Tanti's elder son Viraj Tantis lives with me. Now the informant here is Bhavananda Tati, who lives with his mother,
Yes.
and he is saying that the son of the victim, the Viraj Tati,
Viraj.
lives with him. Whereas PW1, his mother has said, usually he lives with them. But on that night, he has come to watch TV to their home.
No, there is no contradiction. The lives with me on that night, there is no contradiction where he was, the Biraj was staying. He was staying in the house of the informant.
So on that night, he was not there.
He was not there. There is no
Yes.
dispute.
I don't remember who had informed me over phone. On my arrival, I saw lots of people gathered there. About 100 people had assembled there. The police had arrived before my arrival there. So the confession was in the presence of police. I saw the dead body on the floor and it was kept covered. I did not notice where he sustained injury. I also did not see the act. It is not a fact that while making statement before the police, I did not state that the accused had confessed that he had killed Keshav. Mahikanta Tati lives beside the Pakka house. Mahikanta lives in the other part of the same house. I do not know who wrote the Azahar. I just put my signature. The content of the Azahar was not read over to me. It is not a fact that I had adduced false evidence and that I have adduced evidence against the accused out of such speech.
So by the statement that police was already there when he had arrived, you want to assail the part of extrajudicial confession that if it was done also, it was done in presence of the police.
Next is PW3, who is Viraj Tati. I know the informants Bhavananda Tati and accused Arun Tati. It has been 1 year since my father Keshav Tati had died. My father was sleeping inside the house. The accused is my paternal uncle.
PW3 is Viraj,
Viraj,
14 years,
14 years.
student of class 5. Any questions put to him
Regarding his
regarding his maturity,
Maturity and his
ability to
no.
understand? When was this recorded?
It was recorded
August,
on 31st August 2019. It has been 1 year. So when he
after
saw
a
the
year.
incident, it's
After a
13 years.
year. Okay.
So my father was sleeping inside the house. The accused is my paternal uncle. He killed my father. I was not at home at the time of the incident. Later coming home, I learned that my father had expired. I saw injuries on my father's head. this part is important, Your Lordship. Next part.
Yes.
I came to know from the people that the accused had killed my father. So here,
No, even otherwise, he has not said that he has seen.
but
That even if this statement is not there, it has to be hearsay.
yes, but only thing I want to establish, Your Lordship, is that when he arrived at the scene, there was people already present. The villager.
No,
Because-
no. He was there. He only the knowledge of gathering the knowledge of the death. He said that he came to know from people.
Huh.
Because he was the first one to notice this. So there cannot be people.
Otherwise, if he has seen the incident of his father's death,
No, he's not seen the incident. He's seen his father lying,
blind,
dead,
Dead.
while coming to the house. He informed his grandmother and his father
Fa-
and his uncle.
Yes.
And maybe by that time, other people came. This may not mean that I saw injuries and I came to know from the people that only of the fact that father was killed by this accused, that he has come to know from the people.
If we go down, because there is anyway, I will go down, Your Lordship,
Mm.
and read more. I had gone to my father's grandmother's house.
In the evening.
The police came and took my uncle away. My father had a fractured leg at the time of the incident, so it was in a plastered condition.
Mm.
I came in the morning and learned about the incident.
Yes.
Police questioned me.
Mm.
Next is cross.
Mm.
I went to my grandmother's house in the evening.
Mm.
At the time, the accused and my father was not engaged in any quarreling. I do not know what happened after that.
Mm.
When I came back, I found the accused brushing his teeth.
Mm.
My father's dead body was inside the house. I did not find any other person there.
Mm.
I found the doors of the house open.
So that time there were no other persons. He had gone back to his own house, rather his father's house, found the body lying, and people later informed him that it is your father who has killed. I mean, it is the accused who has killed.
But now, when he left from the place of occurrence to his grandmother's house till morning, whether they were together, that is important. Because their explanation to the contrary. So now, if the benefit should go to the explanation or not, that I will say. Otherwise, this time gap is too large from evening till morning. That I would like to. Anyway, PWD 4, Your Lordship.
Just
Here's one of the Caesar witness, Jotin Mohanondia. I know the informant.
just.
The Lordship, just Lordship may turn to page 9 for a moment. Just one line I will take page 9. That is the cross-examination of PW1. Somewhere in the middle, the Lordship, on seeing blood on the act, he said that Arun had killed Keshav. So the PW1 version is that Viraj has said on seeing the blood from the act, he has assumed that the accused has killed the victim. Whereas here he says that he has come to know from the people. And in his evidence across evidence, there is no mention of the act.
Okay.
PW4, your Lord, page 50. He is one of the Caesar witness. I know informant Bhavananda Tati and accused Arun Tati. The incident took place on 29/10/2018. In the morning of that day, people gathered in the house of the accused. Bhavananda is the elder brother of Arun. I am the chokidar of the line. Bhavananda said that Keshav picked up a quarrel with Arun. Police came, blood was oozing out from the head of the dead body. When the dead body was turned over, I saw that there was blood on the ground. When police came, Arun told us that it was he who had killed Keshav. So that is corroborated with PW2 statement that this confession was in the presence of police. The accused himself produced an act. This will I will show conflicts with IO statement. He did not lead the police to the recovery of the weapon. He said that he was killed with an axe. Police seized the axe in front of me. Exhibit 2 is the seizure slip. Exhibit 2-1 is my signature therein. Then cross, hearing a hue and cry, I went there. The incident took place in my line. The incident took place in the quarter of the tea estate. Some 100 to 150 people gathered there. The accused was kept apprehended. The door of the house was closed. Whereas Viraj says I found the doors of the house open. So now, whether the people had gone first and opened the door, because who had come first, then there is a question mark.
The accused was kept apprehended. The door of their house was closed.
Closed.
After apprehending, it was kept closed. It's not before his arrival. See, if you go sequence-wise, hearing a hue and cry, I went there. Incident took place in my line. Incident took place in the quarter of T Estate. Some 100 to 150 people gathered there. Accused was kept apprehended. Door of their house was closed. So he was kept apprehended by closing the door.
It can be, yes, the logic is that it can be read that way.
No, we have to read that way. Andy.
Yes. Two families live in one quarter. Mahikanta Tati lives in the adjacent part. It is not a fact that I did not state before the police that the accused has confessed his guilt. The accused produced the act from the place where he had kept it concealed. It is not a fact that I did not state before the police that the accused had produced the act.
He had denied the contradiction.
Yes, but the IO will say contrary. I will say that he had it was not on the, it was not that accusers led him to the discovery of the weapon. That will come later. It is not a fact that I did not state before the police that the accused has produced the act. The accused confessed his guilt before Bhavananda, me and other people. I have not seen the seized act in the court today. It is not a fact that the accused did not cause this incident, and I have adduced false evidence going beyond my call of duty. Now, Bhavananda says the Lordship,
Yes.
yes, that the accused confessed his guilt before Bhavananda, me and other people, and Bhavananda says that he has arrived after the police. So this is established, the confession is in the presence of police. We will have to now see only on the basis of circumstance. PW5, Mohikanto Tati, who lives in the other part. Accused Oru Tati is the son of my maternal uncle. Informant Bhavananda is his elder brother. One morning about 1 year ago, when the boys of our village assaulted the accused, a commotion took place, whereupon I learned that the accused has killed his younger brother, Keshav. The house of the accused is situated in front of us. I did not go to see the dead body. Orun Tati and Keshav Tati used to live in the same house. I did not hear them quarreling in the night. I learned about the incident only when people gathered there in the following morning. The police questioned me. Then I did not state that I had heard hue and cry. I do not know who had killed Keshav. Your Lordship, he is the immediate neighbor. If there was a hue and cry, you would have heard. Or even if there was a person is killed by an axe, at least there will be some scream. Different.
200 meters.
No, 200 meters is the mother's house, the informant house.
Mohikanta stays in the other part of the house.
Other parts.
Same
Yes,
house.
Same house.
200 meters.
200 meters, Your Lordship, if I may say, is the informant's house. This is Mohikanta, who lives in the same house.
Same house means
The house has got two parts.
which house? This is house.
This is house. This has come up, Your Lordship.
Which is the house of the no, not Mohikanta. No, PO we have seen A. Which is the house of Bhavananda? Lakshmi Tanti and Bhavananda Tati.
Your Lordship may see PW is one statement, page 9,
Yes.
his cross-examination.
Her cross-examination.
Yes.
But his
On seeing blood, the line next to it, he did not incident. The house of Mohikanta is adjacent to that of Keshav.
okay. And that we have also seen from the cross-examination.
Yes.
I mean the sketch map, page
Yes.
80. Now, where is the house of Lakshmi or Bhavananda in the sketch map? No.
Sketch map, it is not come up. Your Lordship.
Okay.
Mohikanta Tati house is B.
Okay. Oh, Mohikanta is adjacent.
Adjacent.
There is only one door. of the house having the place of occurrence?
Basement has shown one door. And there is a Namghar also now. Is this the same house or
No, it has to be the same house.
now we'll take it as
Because there is one door, left side, there may be an Amghar.
right?
In the same room, there is a place of occurrence. The right side is maybe their residential room. Easy to one for
Why I want to stress upon this hearing of sound is that if his presence is doubtful, then whether on the basis of circumstances he can be considered. Because there is one major contradiction in Virat's statement that once he says that he came to know from people, others says that he informed the PW2, who is the informant, PW1, that he has come to know from the blood on the X. And in his own evidence, he says he has come to know from people. So if there is doubt in his deposition, then whether his deposition to the effect that he has seen the accused when he came in the morning can be taken at his face value or can be trusted.
No,
If-
a body is lying in your house. Don't you think that 106 will come in? It will come in.
It will
Definitely.
come in, but if he can provide explanation, which he has done,
What has he said?
explanation is that he has another house. And he was on that night was staying there. In the morning, he has come to collect his bicycle, where he met Virat.
And he was brushing his teeth.
Now that part whether it can be taken,
No.
can be,
That has come on evidence.
that has come of it. But there is contradiction in Virat's evidence also.
Virat's evidence contradiction we have not found, but still then. The X was seized.
But it was not examined. Means in the sense, for instance, the
It was
blood whether it is
exhibited, but no FSL done.
no effect.
And the nature of the injury is medical evidence
Evidence.
commensurate with the
Comments the
use of
weapon.
an X,
Yes.
use of an X.
Yes.
Where was the blow made? Nape. The injury inflicted was on the nape of the body.
Yes. Made it PW6.
Just a minute, please. So far as his place of stay is concerned, PW5, he has not stated that he is in the immediate, he is adjacent to the house of the deceased and accused. Now, he has not said.
Yes, no.
You are borrowing this from PW1.
PW1 and the yes.
Okay. Yes,
PW 6, my lord.
yes.
Amit Orang. I know the accused Orun Tat. Informant Bhavananda Tati is the elder brother of the accused. One day, about 1 year ago, while I was returning from my work, I saw a gathering near the house of the accused. Then I went close to the gathering and learned that accused had killed his elder brother. Yes. I do not remember as to who had informed me. Out of fear, I did not go to see. The police questioned me. The police asked me not to get frightened. There is only one house in between the house of the accused and that of ours. I did not learn about the incident at night. Mohikanti Tati lives in the other part of Arun's house. Now, other part. He lives in the vicinity. I do not know as to how the person died. PW 7, Paul Munda. I know accused Arun.
Just a minute.
Yes. PW 7. I know accused Arun Tati. Informant Bhavananda Tati is my elder brother. It has not been 1 year since the incident took place. On that day, I went to office. In the office, one boy came and said that Arun had murdered his elder brother Keshav. Then I came to Arun's house and saw that Keshav's dead body was lying inside the house and blood was oozing out of the dead body. Police came and took the dead body away. Police seized an egg from the place of occurrence. Exhibit 2 is the seizure list.
He's a Caesar witness.
Yeah, he is the second seizure witness. PW 4. PW
Yes.
On my arrival at Arun's house, I saw about 100 people gathered there. I saw the dead body from some distance. At the time of putting my signature in the seizure list, police did not read over the content of the same to me. I did not see where from the X was seized, as it was night. I put my signature on the seizure list on being asked by the Sukidar of that time.
Why was it at night?
It should be in the morning.
Maybe the police had come and seized it the night or what? The FR was lodged at 11 o'clock.
11 o'clock.
We'll see the IO's version when they had come,
Yes.
when they had reached.
And PW 4 says that it is the accused who has led the discovery. And here, so we have to see what the IO said.
Okay. PW 8.
8. I know accused Arun Tati and informant Bhavananda Tati. The incident took place about 7-8 months ago. I was at home at the time of the incident that took place at night. Around 7:30 a.m., I came to know from the BDP secretary Kotiram Orang over phone that the accused had killed his elder brother Keshav Sati. And your lordship, Viras had visited the place of occurrence at around 9 a.m. And people have come to know around 7:30 a.m. So whether Viras had seen the incident first or he came to know from people when people have already visited the place of occurrence. If there is doubt in that, then there is doubt in his statement that he has seen the accused brushing and there was no people. Then that's it. There is a doubt in his.
This VDP secretary has been examined. Katiram,
No. Not it. And he is the village headman. May I continue?
yes.
Going to Keshav's house, I saw Keshav's dead body lying inside the house and the blood oozing out of the dead body. I saw injuries on his head and leg. On being informed, the PS over phone, police came there. Police sent the dead body for postmortem examination. Police seized an egg. Then I put my signature in the seizure list. Exhibit 2 is the seizure list and Exhibit 2-3 is my signature there. The incident took place at night. When I arrived, some 100 to 100 people had already gathered. But this part is consistent. The people were there on 100 to 100. Arun and Keshav lived in the quarters of the tea estate. There was a fracture in Keshav's leg. Accused Arun and his mother lived together. After one of his legs got fractured, Keshav lived with Arun. I do not know in what state or where the inmates of the house stayed that night. Police arrived after my arrival there. Police questioned me. I did not state before the police that I had found the dead body kept covered. I did not see from which place inside the house the police took out the egg. When I put my signature on the seizure list, nothing was written there. I put my signature as the village headman. So his seizure witness is also not to be taken in. No.
No. Police seized an X.
Hmm.
That part he has said.
Yes, police is
When
there.
he has signed, what was there at the time of signing, that may not be material. If he has not stated that he has not witnessed what was seized, then perhaps. But that may not have too much impact on the
Yes,
prosecution case.
yes. That-
Because if you say that the FSL report was not obtained,
Yes.
neither the bloodstains were sent for serological test.
Viras witness statement is important. And whether he came after the people or before the
The X had contained stains or not?
as per the statement of PW2,
No,
one,
not two. Regarding by IO.
I
Okay, let us go serially. We'll get
Serially.
something.
PW9 did the inquest. On 30/10/2018, I was working as an assistant commissioner at Vishwanath Charity. That day, receiving a police requisition in connection with Vishwanath Charity PS case number 7, so I went to village Takomato Paka line for holding inquest. There I held inquest on the dead body of Keshav Sati. Holding inquest, I gave report as follows. Description of the wound, color black, 3/4 inch, wearing half pants, 14 clothes, mouth closed, eye open, hair cut. Presence of wound, cartoon marks in the left rear side of the head and on the right forehead. I have found only the carbon copy of my report. My original inquest report is not in the case report.
He is an assistant commissioner and executive magistrate.
Yes. PW 10
mm,
is the medical officer.
15.
There are two wounds on the head.
Two wounds, marks on the left.
PW 10 euro. On 30/10/2018, I was at Behali block as senior medical and health officer. On that day, I conducted postmortem examination of Keshav Tati, male 40 years by reference of so-and-so, dated so-and-so, identified by under 560 up to cover. The findings are there was an incised wound of size 1 into 0.5 inches over the left supraauricular area and another 2 into 0.5 inches on the infraauricular area. Both were in the left side of the scalp. Depth was up to the scalp. So there were two vital blows on the vital organ of the body. Another incised wound was 3 into 0.5 inches over left temporal occipital area. Incised wound means was caused by sharp cutting weapon, but I have not specifically mentioned that the injuries were caused by sharp cutting. This cross exam. Yes. PW11 is the IO. On 30/10/2018, I was working as an ASI at Vishwanath Saili police station. On that day, officer in charge of the PS received an Azahar. The first information was on the next day. Before that, on 30/10/2018, VDP Secretary Jatin Mohananda informed the PS over phone that accused Arun Tati has assaulted his brother Keshav Tati with sharp weapon, thereby causing his instantaneous death. So it is the VD who has informed the police, but he had come to know around 7:30. Viras has visited the place of occurrence at around 9 a.m. The villagers caught Arun and kept him confined. Accordingly, after making DD entry number so, the OC sent me to the place of occurrence. At the place of occurrence, we took accused Arun Tati in our custody. On being shown by him, I seized the axe with the accused has killed his elder brother. This I stand corrected. On being shown by him, I said. And interrogated the witness of the seizure list. Exhibit 2 is the seizure list, and Exhibit 2.4 is my signature therein. Executive Magistrate Pranjal Das came there and held inquest on the dead body. Taking the dead body and the accused along, I went to the place of occurrence. Thereafter, Bhavananda Tati lost the Azahar. Then the officer in charge registered the case and entrusted me with the charge of preliminary investigation. Exhibit 1 is the Azahar. Exhibit 1 is the signature of which I have recognized. I sent the dead body to Behali for postmortem examination. Thereafter, I again went to the place of occurrence and questioned the witnesses. I interrogated the accused in the police station and arrested him. On the following day, I forwarded him to the court. The seized act was made seen in the court. I made a prayer for recording confidential statement of the accused, but I am not aware whether it was recorded or not. I collected the postmortem report. After completing the preliminary investigation, I handed over the case diary to the officer in charge. Thereafter, SI submitted charge sheet. Exhibit 4 is the case map of the place of occurrence, and Exhibit 4.1 is my signature diary. Exhibit 4, there is the CD. I have seen the seized act in the court today. I have recognized. Material Exhibit 1 is the state seized act. Cross-examination. The GD entry was made around 8:30 a.m. I immediately went to the place of occurrence. Around 60 to 70 people gathered at the place of occurrence. The place of occurrence was 2-room quarters of the tea garden. It was a single house. I did not seize any bloodstained clothes. I did not send the X to fingerprint expert. I did not send any article to FSL. The two brothers and the children of Keshav lived in that house. It is not a fact that while making statement before me, witness Viras Tati stated that there was a quarrel between his father and uncle. I recorded the statement of Viras Tati, Lakshmi Mani Tati, and Jatin Mahanandia, Mohikanta Tati, Amit Orang, and on the day of the incident itself. I did not record the statement of Uttam Tati, who resided near the place of occurrence. I also did not record the statement of Rajesh Orang. The house of Lakshmi Tanti is about 1 furlong away from the place of occurrence. Jotin Tati is the VDP member. Teniram is the village headman, and Jotin Mohanandia is the stockkeeper of the line. There is no mention about the sketch map in the charge. I did not notice blood on the X. That's all. It is not a fact that I had investigated the case or found the Your Lordship, then his statement under 313, the explanation I want.
He did not notice blood on the X.
X. So whether that is the X, that has not been identified. But one thing he says, he was led to, he was shown by the
Accused,
accused.
appellant. What about bloodstained cloths? Nothing.
Nothing. He says in his cross-exam, nothing was said. So that Viras statements become fight. Do you want to see your Lordship? May I take to page 38?
Who is this? Another?
Another, because he was put, 313 was initially
No,
asked.
what is page 33?
33. IO. Here, he has mentioned about his name in his deposition itself.
No, PW 10 is the doctor. Why is he again said to be PW 10? Can't be 11. It has to be 12. 11 is the ASI.
Yes,
Pranab. He is on Farooq.
he is the one who submitted the start sheet.
Should be 12, I think.
Yes.
He submitted the charge sheet.
Start.
Yes.
Page 35 and page 38 I will write. Question number 4.
Yes.
PW2 Bhavananda Tati informant has said in his evidence that you live with Keshav Kanti in a house which is about 200 meters away from their main house. What is your say in this respect? It is false. I have my house in the bus. I lived there on that day. I came to the quarters of Keshav for taking my bicycle from there. I do not know what happened. And similar again.
He is taking a plea of alibi. He was somewhere else. Alibi.
Alibi. He has his own house. That whether he has an own house or not, that has not been gone into the by the prosecutor. And even if it is true or not true, if it is a possible hypothesis, we have to. Then
But alibi has to be proved. You're just simply saying that in 313 I was not present.
no, he has another house.
No, it has to be proved. This 313 response is not even under oath. It is not evidence.
Okay.
You give a chance to him that this is incriminating materials against you. What do you have to say? Give him an explanation, opportunity to explain. If he says that I was not present, that means you are somewhere else. You have to prove it, either
Right.
by yourself giving evidence or through other defensive evidence.
But if I may say, from the evening to the morning, whether he was present in that house, whether he stayed in that house, the prosecution has not been able to establish that. It is presumed that they used to live together. And on the
No,
morning,
to argue that, there has to be at least a suggestion in the cross-examination part
right,
that night he was not even there. There has to be some foundation from where you can make an argument. Criminal trial, there is no
And-
pleadings.
otherwise,
If you can show somewhere in the cross-examination that this is a line which you wanted to take as a defense, maybe there will be a denial or something, but
And
once you
but that-
answer question number 4, that your presence you're yourself disputing, then you need to prove that.
that was
The
They have
the
not-
standard may be different. We have held in other cases. But alibi is a defense, you need to prove it.
then similar explanation he gives in page 38 of
3-8.
3. Subsequently, on 5/3/2022, 2 more questions are put to the accused Orun Tati under section 300, which are as follows. PW3 Viraj Tati has said in his evidence that in the morning when he returned home, he found by you brushing teeth outside the house and the dead body of Keshav Tanti was lying inside the house and the door was open. What is you say on this piece of evidence? I have my house in the Basti. In the morning, I came to the quarters of Keshav for taking my bicycle, which Shiraz, the brother of Viraj, had taken from me. And then people got. They took 30. Now, flip the dot. From evening to morning, he was there till the morning. Only person who has said is Viraj. He is the person who has said, I saw while coming, there was no people, but I saw it to complete the chain. But his statement, in my humble submission, whether his position is truthful or is doubtful, because there is contradiction in his statement. So on the basis of that, whether the chain is complete, whether there are gaps, if his presence in the morning has not been proved beyond reasonable doubt by the prosecution, whether on the basis of certain circumstantial evidence he can be convicted.
Okay.
In that regard, the circumstantial evidence I would like to determine a judgment.
Citation, please.
2016 PGLP 358.
Name?
Name Petru Conver and another versus state of Assam.
Yes, which para?
Para
What proposition?
This is where on the basis of circumstances, the chain has to become. If there's even a
Which para?
23, 24, 26. And 27. LP.
Just one. Yes.
20. The above mentioned informatives in the instant case have rendered the prosecution story not only wholly not
Para
reliable.
23.
23. The mere fact that the two accused persons have taken away the disease in the afternoon and on the next following day that the body was recovered is not enough to prove the charge unless other aspects of proof. The learned trial court has given much credence upon the testimony of the witness without considering material contradictions, omissions of the above referred witnesses.
Which para you're reading?
23.
But
Faith-
it is something else. It is submitted by Miss Ed Jahan. She is here, has not submitted anything.
Oh, sorry.
You have given the Petlu Kaur.
That I will deny later a lot. Sorry.
Petlu Kaur is more on the 313
316 and also leading to
discovery.
one theater
2016,
16.
one GLT.
And
No, GLT you have
yes,
said. 639.
yes,
Akzar.
yes,
Akzar Ali.
yes.
Asgar. Which paragraph?
This same 23.
Oh, 23, oh, 20. This, okay, this pertains to this. Okay. 23.
LB.
Yes.
The above mentioned informatives in the instant case have rendered the prosecution story not fully reliable. The mere fact that the two accused persons have taken away the disease in the afternoon and then on the next following day dead body was recovered is not enough to prove the charge unless other aspects of proof. The London trial court has given much credence upon the testimony of the witness without considering material contradiction, omission of the above referred witness. The evidence of the IO as regards search and seizure has also been relied, even though such search and seizure is not supported by the witnesses. Though the evidence of the investigation officer is not inherently to be doubted, But the mandate of law is that such certain seizure where the case is solely related to circumstantial evidence has to be proved in due manner, where purportedly the such seizure were made in the presence of witness. The learned counsel for the appellant has relied upon the decision of the Honorable Supreme Court in the case of Tanvivan Pankaj Kumar Divekya versus State of Gujarat, reported in 1997 7 SCC 156. It has been held that in case of conviction based upon circumstantial evidence, each and every incriminating circumstances must be clearly established by the reliable and clinching evidence, and the circumstances so proof must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn, and no other hypothesis against the guilt is possible. In a case depending largely upon circumstantial evidence, there is always a danger that conjecture and suspicion may take place of legal proof. The court must satisfy itself that various circumstances, the chain of events has been established clearly, and completed chain of events must be such as to rule out a possible likelihood of innocence of the accused. When the important link goes, the chain of circumstances gets snapped, and the other circumstances cannot in any manner establish the guilt of the accused beyond all reason. The court has to be watchful. The lordship knows this, but I'm relying on 24, 26. 26 deals with the time gap, your lordship. And 27 is important. And lordship, the other judgment which I just did, that is also related to the child's paragraph 25. That is the testimony of a child. Hmm.
25.
Yes. And 50 is P13. And 56 is circumstantial evidence. May I just read 50? The statement made by an accused under section 313 can be taken aid of to lend credence to the evidence led by the prosecution, but only a part of the statement under section 313 cannot be made the sole basis of his conviction. Statement under section 313 CRPC can either be relied on in whole or in part, and it may be possible to rely on the inculpatory part of the statement of the accused if the exculpatory part is found to be false on the basis of the evidence led by the prosecution. Though the statement of the accused under section 313 is not a substantive piece of evidence, it can be used for appreciating evidence led by the prosecution to accept or reject. However, it cannot be a substitute for the evidence of the prosecution. If the prosecution evidence does not inspire conviction to sustain the conviction of the accused, the inculpatory part of his statement under section 313 cannot be made the sole basis of his conviction. It is obligatory on the part of the accused while being examined under 313 to furnish some explanation with regard to the incriminating circumstances associated with him, and the court must take note of such explanation in case of circumstantial evidence to decide whether or not the chain is complete. So I am relying on this last part. And 56 is again regarding the
50.
circumstances. So I'm relying these three paragraphs. And one last judgment lordship, there is two possible hypotheses. Two hypotheses are possible than the one benefiting the accused be regarded. This is 2023 5 SCC 350. Pradeep Kumar versus State of Chhattisgarh.
Yes, copy. You have copies?
Yes. Paragraph 27. This judgment also deals with circumstantial evidence, but that is an extra. But paragraph 27 and 28. It is important to note that the cardinal principle in the administration of criminal justice in cases where heavy reliance is placed on circumstantial evidence is that where two views are possible, one pointing to the guilt of the accused and the other towards his innocence, the one which is favorable to the accused must be adopted. In the present case, we state that the circumstances present before us, taken together, do not establish conclusively only one hypothesis, that being the guilt of the accused Pradeep Kumar. The presumption of innocence remains in favor of the accused unless his guilt is proven beyond all reasonable doubts against him. The cherished principle of golden phase of proof beyond reasonable doubt, which runs through the web of our law, should not be spread morbidly, which was done by the court. Because I think Viras is the only witness whose statements complete the chain. Because he comes in the morning and says he has not seen other people and he has seen the accused, the appellant here, brushing his teeth. But whereas he comes to the place of occurrence at around 9 a.m. The other people has 100 to 100 people has gathered, whether they have gathered before or after. The VD village defense state witness, he says he has come to know around 7:30 and informed the police over phone. So this creates doubt on the statement. Virat.
Here, PW1, my lord Lakshmi Tanti, is the mother of the victim as well as the accused person. She says that your lordship is deposed, that accused and the deceased is to live together, your lordship. Lordship, may kindly have a look at evidence of PW1 at page 8. accused Arun Tanti is my son. Informant is also my son. About 8 months ago, my son Arun Tanti killed his elder brother Kekop Tanti following a quarrel. At that time, I was in the informant Bhabananda Tanti's house. Arun and Kekop stayed in the company's house. I was at Bhabananda's house, which is at a little distance. The incident took place at night around 8-9 a.m. On the following day, my grandson Viras Tanti went there and said that his father had been killed and that he did not know as to who had killed his father. Going there, I saw that Kekop had already died. There was an injury in his neck caused with an axe, and there were injuries in different parts of Kekop's dead body. The dead body was lying outside the quarter. The police came later, says my grandson Virasani said Arun had killed his father. Police questioned me. Then cross-examination, my lord. Arun and Kekop lived together in a Pakka house. Kesop's son Viras Tanti also lived with them. The house of Rajesh Orang and Mohikanto Tanti are situated nearby. I do not know at what time Kekop died. I also do not know who killed him and how. At the time of the incident, Viras was not present at home. He had gone to watch TV and slept there at night. He was killed with an axe of their house. On seeing blood on the axe, he said that Arun had killed. He did not witness the incident. The house of Mohikanto is adjacent to that of Kekop. Mohikanto lived with his family, and there are 4 members in his family. On entering the house, I saw Kekop lying on the ground of the first room. The door was open. It is not a fact that I did not state before the police that I saw blood oozing out of Kekop's name. It is not a fact that I have adduced evidence against the accused as tutored by the informant. Then the evidence of Bhabananda Tati, who is the elder brother of the deceased, my lord, as well as the accused. Page 11. Accused Arun Tanti is my younger brother. I am the informant. The incident took place 7-8 months ago. My mother and I live in a Kelsa house. Both Arun and Kekop are my brothers. They live in Pakka house. They live about 200 meters away from us. My younger sister Nirachi Tati came to our house while I was going to my brother-in-law's house at Tangla to leave my sister there. One of my neighbors informed me over phone about the incident, and Arun Tanti had assaulted Kekop to kill. Then I came back. I reached home at around 9:30 a.m. I saw Kekop lying dead. Arun said that he had killed Kekop by assaulting him with an there's extrajudicial conviction. Arun and Kekop engaged in quarreling after consuming liquor. On the previous night, an incident of assault took place. I saw cut injury in Kekop's neck. Police came. Police brought the dead body to Bihali for postmortem examination. Police questioned me. Kekop Tanti left 2 sons, Siraj and Viras. Is it about 10 years and 8 years? Thereafter, I lost them. So then further process there. It's crossed, not further process. If a hue and cry is raised at a Pakka house, it is not audible from our house. Kekop Tanti's elder son Viras Tanti lived with me. I don't remember who had informed me over phone. On my arrival, I saw lots of people gathered there. About 100 people had assembled there. Police had arrived before my arrival there. I saw the dead body on the floor and it was kept covered. I did not notice where he sustained injury. I also did not see the axe. It is not a fact that while making statement before the police, I did not state that the accused had confessed that he had killed Kekop. Mohikanto Tanti lives beside the Pakka Ghar. Mohikanto lives in one part of the same house. In the other part of the same house. So it's near the residence of Mohikanto. It's just it's adjacent, my lord. Then the evidence of my lords. Viras Tanti, my lord, is a nephew.
No, Mr. Sharma is trying to build up a case regarding both of them staying together in the house on the night of the occurrence.
Yes.
He is saying that there is no evidence.
But lordship,
What
there,
he is trying to highlight is that Viras, the nephew,
yes.
and the son of the deceased, when he had
Viras,
gone,
Siraj, a son of Kekop, deceased.
deceased,
Yes.
Viras had gone,
Yes.
and by the time Viras had gone, 7:30 the GD entry was already made.
Yes,
Viraj had gone there around 8 to 9.
my lord.
And Viraj says 8 to 9, 100 people were already there. It has come out with other evidence. And he was confined. Viraj says that I had gone there, I saw him brushing his teeth. And
Would it be the contact of a brother whose own brother has no remorse, nothing?
No,
Not
no,
remorse, my
no.
lord, no reaction,
no,
unnatural behavior.
no, that is not what Mr. Sharma is. He's trying to project that whether the testimony of Viraj is believable at all.
Lordship, I want to give emphasis on a point, my lord, whether this person, accused and deceased used to live together or not.
Yes, on that.
Yes, my,
No,
So-
there is evidence.
My lord.
They used to stay together in the Pakka house,
Yes.
company's house.
my lord.
What is material is that on that relevant night, whether both were there in the house. If both were there, if you can discharge that burden, that 106 will automatically come
My
and
lord.
you explain. Your dead body is in your house, you have to explain. Now he's trying to make out a case in his 313 that he had come to only take his bicycle. Of course, that saying in 313 will not
Will not do.
He has to
establish
prove it.
positive evidence, my
He has to
lord.
prove. But at the same time, we need to satisfy ourselves whether his presence was otherwise has been proved by the prosecution.
Except certain PWs have deposed, they used to live together, but on the relevant day,
Relevant night.
it was there or not. But evidence of PW1, I think your lordship will suffice, my lord. And lordship will consider PW1 is none other than the mother of both.
No,
why
no,
she lived-
we will go by the meaning of the evidence.
My lord.
Who is giving the evidence is not very concerned.
My lord.
What has been said is more important.
Lordship, second line at page 8. About 8 months ago, my son Arun Tanti killed his elder brother Kekop Tanti following quarrel. At that time, I was in front of Bhavananda Tanti's house. So she was talking about a quarrel which has taken place
No,
on the relevant day.
No, there has to be evidence. She was staying at 200 meters. How can she be a witness to a quarrel? That means she have heard from somebody. We have to go by evidence which is admissible.
Her evidence could not be destroyed. I don't find.
No. She did not say that I saw them quarreling.
No. Seeing doesn't matter whether they used to live on the very relevant day.
Yes.
Yes. So he discharges his burden under section 106.
No. Where
Once it is established, my lord.
from where it is established that on that relevant night they were together.
Lordship, about 8 months ago, she said, although she has not mentioned, my son Arun Tanti killed his elder brother Kekop Tanti following a quarrel.
Hmm.
At that time, I was at the informant Bhavananda Tanti's house.
Hmm.
So,
Bhavananda's house is 200 meters.
yes, but it's a part of, they used to live in a kacha house, whereas the accused person used to live in a pakka house along with the deceased.
Yes.
It has come upon the evidence.
No, their houses are different. It's 200 meters. The deceased and the accused used to stay in the same house, and one part Mohikanto used to stay.
Yes.
This is a Kacha house, this is different. Even their house
No
is not.
coincidence, it's
No,
part
it's-
of the same house.
No. It's Mohikanto. You see the sketch map, their house is not even there.
It's not the same house.
Mohikanto stays in this another part of that house.
Adjoining.
That is why we are trying to ask and understand.
Perfect statement.
You come to PW2,
Yes, I'm
PW2 page 11, page
Yes,
11,
yes.
page 11. You'll get
Kacha house, both Arun and Kesav are my
Fourth
brother.
line, they live in a
Yes.
Pakka house, they live about 200 meters away from us. This is what Bhavananda.
Yes.
And mother used to stay with Bhavananda.
Mother used to sleep.
200 meters is not very near.
But your lordship, extrajudicial confession.
Before
There,
police.
although it's a, no, not before police,
Before police.
not before police,
Yes.
my lord.
Before police.
Police had already reached.
It is the PW2, my lord.
Before his cross, he says about extrajudicial confession. I saw Keshav lying dead. Arun said he killed Keshav by assaulting with an axe. And when did he know about the incident? He was going somewhere. He reached around 9:30, and police had got the GD entry at what? 7:30.
Then before PW4 also.
Extrajudicial is by PW2.
Yeah, PW4 also.
PW.
4, my lord, page 17, last part, 4 times from the bottom.
Yes, in front of police. Page 16. It starts at page 16. Come to page 17. Page 16, the last line. Bhavananda and Keshav picked up a quarrel with Arun. Police came. Blood was oozing. When police came, Arun told us that he killed Keshav. When police came.
Page 12, cross-examination, PW2.
This extrajudicial perhaps is not, may not come into play.
Then pardon under 106, my lord. But I don't see any positive evidence on the very relevant that she was there.
Mohikanto would be relevant. What does Mohikanto says?
Mohikanto said in the cross-examination, Arun Tanti and Keshav Tanti used to live in the same.
No, not used to. That evening, what was his experience? PW5, page 18. He starts with one morning. He doesn't say anything about
One
the
morning,
previous evening.
He talks about subsequent events. One morning, about 1 year ago, when the boys of our village assaulted the accused, a
No, that was
commotion took
when he
place.
was assaulted, when he was apprehended.
Yes, that time.
And Keshav used to scream, I did not heard him. And see, he did not hear them quarreling at night. Cross-examination. Second line, one page 18, page 19.
I did not hear them quarreling in the.
I heard about the incident only when people gathered there in the following morning.
As per evidence of PW6, Amit Ora,
Yes,
Mohikanto Tani lived in the other part of Arun's house.
yes, same.
He did not hear it.
They did not hear. There's only one house in between the house of the accused and that of. And he also said in cross-examination, I did not learn about the incident at night.
Even PW8 is saying Arun and Keshav lived in the quarters of the tea estate. There was fracture in Keshav's state.
X was not having any blood stain.
That's pain. And it was Whether he was taken into custody or not, it's not apparent. On being shown by him, I seized the axe which the accused had killed his elder brother. Before that,
No, leading to discovery may still be there. Custody doesn't mean that he has to be in the police station. Custody
no,
means
prior to that, he has to.
they had come. They were in the he was apprehended. But leading to discovery is a relevant fact. But how do you link the
That is
acts?
it.
That recovery, discovery, we will admit that's a relevant fact under 27. But you have to link the weapon with the accused.
Then do you want to state an explanation? Apart from that,
He is a bachelor,
I.
369, para 87.
Actually, evidence of PW3, he didn't say that he was not available. PW3, Viraj Tanti, he says at that time in cross-examination at page 15, at that time the accused and my father were not engaged in quarrel. So, his presence is established here. He was present, he was not quarreled, but he was not quarreled.
No, Biraj was not at, he was in a different place. Biraj is the son of the deceased. He was staying in the house of Bhavananda.
He used to stay, my lord.
No, that evening he was not staying at that place. Please read Biraj again.
I know informant Bhavananda Tanti and accused Arun Tanti. It has not been 1 year since my father, Kekop Tanti, had died. My father was sleeping inside the house. The accused is my paternal uncle. He killed my father. I was not at home. Yes. I was not at home at the time of the incident. Later coming home, I learned that my father had expired. I saw injury on my father's head. I came to know from people that the accused had killed my father. I had gone to my grandmother's house.
Yes.
The police came and took my uncle away. No, he talks before, it can be understood. Before going to his grandmother's house
Yes,
in cross-examination.
yes,
I went to my grandmother's house. So
yes,
he talks about that point of time
yes,
in the evening.
at that time,
At that time,
yes.
the accused and my father was not engaged in.
The body was found in the morning.
But the explanation given by the accused person, he doesn't stay with him. He stays somebody else. He came in the morning only to pick up the bicycle. But as per the evidence of PW3, he was available. He was not quarreling with the deceased person. At the time, in the evening, when he went to his grandmother's house.
The gap, evening till the morning. I do not know what happened there after that. When I came back, I found that the accused brushing his teeth. Father's body was inside the house. I did not find any other person there.
Yes.
Investigation, there is much is lacking. Okay. Anything else? Biraj is PW 3.
Biraj is PW3. And there's no event crime on the part of the accused person. If you would have witnessed the occurrence, since this brushing his teeth when PW3 arrived, he was like calm and cool. I'll be relying on Trimukh Mar 2006 10
Yes, please. Citation
Trimukh 2006 10 STC 681
2006.
10 STC 681. Trimukh
Six.
Maruti Kirtan versus State of Maharashtra.
Para
Para 12, madam. 12, 14, 15. 18, 21 and 20. regarding fee of alibi,
This one.
we are making the state. We'll be relying on 2010, 8 SCC, 430. Para 30 to 36.
2000?
2010, 8 SCC, 430.
430.
Yes, your lord. Para 30 to 36. Sheikh Sattar was the state of Maharashtra. Mayor giving fee of alibi will not do. Mayor, the fee will not do unless they keep positive.
Sheikh?
Hello?
What is the name?
Sheikh Sattar was the state of Maharashtra.
SH.
SHAIKH.
Sattar.
SHAR was the state of Maharashtra.
Yes. Okay, that's all. Okay. R. Sharma. No? Amicus. BBS Senior Counsel. APP. Hearing is concluded. Judgment reserved.
Obliged.
No respite. No respite for you tonight. She has completed already.
Yes, Lordship, Lordship, I want to show the GD entry. The entry at page 107. Ejaar was lost on 4 p.m. and the GD entry was, because why I'm mentioning it, Lordship, the
107.
appellant had taken the plea that he had called the 100, dial 100, and the GD entry also shows that someone had dialed 100 from one phone number, although that phone number, whose phone number, that was not established. So in his 313, he had taken the plea that to, as he was, the people were attacking him, he, after closing the door, called police. And that is, GD entry is also clear that it is dialed by someone, and who had dialed it, not there. Although some of the witnesses want to say that the Gaupura had dialed it, but the Gaupura, who was still alive as per the evidence, was not examined. So, Lordship, here now, GD entry shows that information by dialing page 107. Now, information has been given over phone by test to PCR that certain person gave information by dialing 100 from the phone number so and so that the public kept their boy confined in a house at Dow Parbatia, Outdoor Sukuri. On being informed so and so, the police subsequently came, Lordship, and that is in his 313 statement. The petitioner appellant had taken that plea that he had dialed police, and page number 49, Lordship, in reply to question number 2.
Page number
49.
49.
Yes.
Question number?
In the topmost question number 2. Seeing many person out of fear, I remain inside the room and dialing 100, call police. That is one thing. And other thing is that Lordship, although section 27 was not discussed, but regarding that, what I found after reading again, Lordship, that he had not taken the he had as per the IO, he had only stated that I have buried the body in the well, but it is not that he had taken the police, although it is in the same compound as per the evidence. And so far the head part, Lordship, if we'll go by the evidence of PW6 PDP, that is I want to read it. Page number, start from page 29, last 4 lines. Start from last 4. Accordingly, police came and during interrogation, the accused admitting his guilt stated that he killing his mother threw the dead body in the well. Fire brigade also reached the place of occurrence. Police recovered the dead body from the well. The dead body was found covered with garbage, branches of trees, etc. Beheaded dead body was in a jute bag. To prevent the accused from public assault, police took the accused from the midst of public. In the police station, on being asked about the head of the dead body, the accused told that he had thrown away the head in a pit in backside of his house. I brought out the head from the pit. So it is by PDP Secretary PW6. And the leading to that, there is a difference of time, Lordship, because if we go by this, that regarding the body, it was at the place of occurrence and he was taken to the police station, and that head part he had stated only in the police station. And IO had also stated that regarding the body, Lordship, only he had stated that it was in the well, Lord. Not that he had even he had not went to the place of occurrence. And what his admission before the police, except PW3, he has stated that I was there when he had made the submission. Others have submitted that they have not heard what the appellant had stated to the police because it is inside the house. Other evidence is that they have not heard what is the conversation between the police and the accused appellant.
First, I want to read the evidence of PW3. Hono Kanto Potong, the immediate neighbor,
Page?
page 16. I am the neighbor of accused Rupajyoti Bora. Incident occurred on 25/6/18 at around 10 a.m., 11 p.m. On that day, your Lordship will kindly mark the time. On that day, at around 8 p.m., I went to invite Bhakat for the Nam to be held in the next day of Namghar. And at around 8:30 p.m., I returned home. Your Lordship will kindly note the time. 8:30 p.m., I returned home. At that time, I heard quarrel between accused Rupajyoti Bora and his mother, Gunaprabha Bora. I heard crying of Gunaprabha Bora. On earlier occasions also, they used to pick up quarrel. Hearing cry of Gunaprabha Bora, when I inquired her from my campus what happened, she replied that her son, Rupajyoti Bora, fell down dal prepared by herself, saying that it is not tasty, and hence she again prepared the dal. Then I asked her to come to my home if he is quarreling with her, but she refused saying that she would remain in her house whether her son cut or kill her. Then I entered into my house. In the morning, I had seen Rupajyoti Bora throwing some garbage. Your lordship,
This exchange was not from his compound. It was from the road perhaps.
but
Then I-
wall is 5 feet, but
No, then I entered my house.
yes, that's there.
So the aspect of wall may not come in now,
But
but only for the conversation. So far as the witnessing of the throwing of garbage,
yes,
that part.
yes. But I have seen it's a wall, not a fence, my lord. It's a wall, it's of 5 feet. But lordship, prosecution could not.
No, in the morning, I had seen Rupajyoti Bora throwing some garbage in their
Yes,
path.
he witnessed, my lord. And this one, my lord, sketch map also substantiate that. I'll try to satisfy a lot. Then in the morning, I had seen Rupajyoti Bora throwing some garbage in their well. Lordship will kindly note that part. Then I informed the brother of Punaprabha, namely Jibon, about the quarrel on last night, as well as throwing garbage in well. Then Jibon, along with 2-3 others, came, and on being inquired, Rupajyoti Bora himself before villagers admitted that he had cut his mother, Punaprabha, with a kukri and threw the dead body in the well. Then the villagers called Gaubura, and on being informed, police also came. Police brought out the dead body from the well. The torso of the dead body was found in a bag, and the head was recovered from a pit in backside of the house of the accused. Police took the dead body for postmortem examination. Then his statement was also recorded under section 164 CRPC. He says after 2 weeks, my lord. It was recorded on, my lord, 36,018 after 4 days. Incident is of 25. Right. Then he reiterated his statement what he made before the magistrate at page 19, third paragraph. Before magistrate, I stated that at early morning, seeing the accused throwing some garbage in a well, I suspected that he might have killed his mother and threw the dead body in the well. Before magistrate, I also stated that on being inquired, the accused told Jibon Bora and the villagers that his mother went out to visit someone on previous day. I also heard the same statement from the accused. Now, your lordship, I will be relying on the 164 made by this witness at page 91.
Yes.
At about 9:30 p.m. on 24/6/18, Punaprabha Bora had a quarrel with her son Dhruva Bora. Although he says in Chief Mala, it was around 8:30. A little bit of this. My house is continuous to Punaprabha Bora's house. That day, when I was returning from the house of one Bhakot and reached near home, I saw Punaprabha Bora sitting on the veranda. So, lordship is correct, your lordship. It was not like he was not on the other side of the wall. From the road only he entered. I saw Punaprabha Bora sitting and crying on the veranda, and on being asked, he said that Dhruva thrown the dal cooked by her, saying that that the dal went bad. After hearing that, I went inside my house. After that, I heard commotion in their house. Oh, lordship, then he went inside the house. Then after that, I heard commotion in their house from 11 p.m. to 12 p.m. Thereafter, as it rained heavily, I could not hear the commotion anymore, and I fell asleep. So there would be 2 parts, my lord. One, on the point of throwing dal, my lord, and another subsequent quarreling. Thereafter, as it rained heavily, I could not hear the commotion anymore, as I fell asleep. At 4 a.m. the following day, when I went for morning walk, I saw Dhruva throwing some vile things and garbage into the well.
When I went for morning walk.
Yes. So morning time she used to go for morning walk every day.
When I had, what was the day?
It was of
What time? Oh, June.
June.
Possible 4 o'clock
Yes,
in a village.
yes. Then a suspicion grew in my mind that he might have killed his mother and thrown her body.
So, the witnessing of throwing the garbage is not necessarily from his house.
Yes,
It can be from the road also,
Yes,
because
correct.
while he going out and front part was open.
but one of the witnesses have seen blood stain in front of the door.
No. The argument which was trying to be projected by the learned amicus, that there was no scope of witnessing the garbage being thrown, as there was a brick wall of around 5 feet. So, but he says that it is not necessarily from the house. He had come out for the morning walk. He could see that because front side was open,
My lord.
that the garbage was being thrown, and he became suspicious. Previous evening, from coming from the Nam, he saw some commotion, crying. Next morning, garbage being thrown. So he went to Jivon's house, informant's house.
Then a suspicion grew in my mind that he might have killed his mother and thrown her body into the well. So I went to Jibon Bora's younger brother of Gunaprabha Bora house, at a distance of about 1 kilometer from there, and told him all the things. Then Jibon Bora came with some fellow villagers and questioned Rubo where his mother had gone, as he could not see his mother, who always used to sweep the courtyard and wash dishes outside in the morning. Jibon Bora, with a dagger in hand, so it could be the accused person, with dagger in hand, was sitting in front of the door of his house. And on being asked by the people, he said that his mother had gone for outing on the previous. Then he went inside the house and remained there. Thereafter, when the police went there, he attempted to make an assault on them with a dagger. Then some 4-5 police personnel went inside, and when they questioned him, he said that he had killed his mother and thrown her body into a well. The police went to have a look at the well immediately, and after lifting the garbage from the well, they found a dead body in his mother. It was a beheaded dead body. Police asked Rubo what he had done with the head, and he said that he had kept the head buried in a pit near the latrine and covered it with a garbage. Going to that place, the garbage was removed and the head of his mother was found. Regarding plot of land, quarrels had been going on between Rubo and his mother since about 1 month. Rubo's mother told him that she would sell the plot of land, that she would set up a store for him with the proceeds, and she would get a house constructed with the remaining amount of cash. But Rubo wanted the entire amount of money. He often quarreled with his mother over that issue. We saw that Rubo had washed the veranda at the back of his house with water. So there's a this evidence has come up, wipe off the evidence. None other than Rubo and his mother lived in their house. I have only this much to say. Now I'll take your lordship straightway to the sketch map, my lord. Page 108. A is the residence of PW3 Honokan. In between there is a lordship wall. Then, my lord, well, your lordship will see it's nearby the wall. When my learned friend has made this submission, not possible, but it could be. Well is F, my lord.
No, well can be seen if he is on the road.
If it is on the road, that can also be seen. Now, I rely on the evidence of the doctor, my lord. PW7.
Page
PW7.
30,
Next page, page 34.
34.
Lordship, here at 4 p.m. he conducted the autopsy. Page 35, the opinion, madam. The same day at 4 p.m. he conducted the autopsy. Lordship, may I take your lordship to the post-mortem report at page 95?
Yes, please.
Page 96. Condition of subject stout, emaciated, decomposed, etc. The head of a female person without body, of moderate complexion, eyes closed, mouth partly open, body cold on touch externally. Lordship will contain notice for rigor mortis present over the eyelid and chain, hearing present in both the lobes. Then your lordship, time since date has been mentioned at page 100. Last line, approx time since date 12 to 24 hours. So when the examination was done, your lordship will kindly note 25/6/18, page 96,
At 3:15.
3:15. So your lordship, if you reverts back, it's between 12 to 24 hours. It's possibility, your lordship. It's the occurrence has taken place within that hour. And another factor, my lord, if your lordship sees, is the contents were found on her stomach, your lordship.
Half digested. Well, found.
Lordship.
Partly digested food
Yes.
material.
So lordship, he had after dinner, the occurrence had taken place. So lordship, Dr. opined that the death had taken place within 12 to 24 hours. And during the very point of time, the victim was very much present at the place of occurrence along with the accused person. And your lordship, the one accused has taken a plea that she had gone somewhere, my lord, has not come back. But no, nothing, no, he had not made any inquiry, no police, no complaint before the police station.
No, that was only in the evening.
Last evening, my lord.
Evening.
But
It may not be.
mother
had it-
doesn't come back.
Had
We
it
should
been an
have,
unnatural delay, that this aspect would have been relevant. But probably he has said that as a matter of excuse, but to examine that, not calling the police or not complaining may not be very relevant.
but she, at least he could have made, he went, or at least lordship inquired with his neighbors, my lord, as regards that his mother had
No,
not
early
come.
morning, the people gathered only from 4 o'clock it started.
And although another witness, he has deposed that he went out for saloon, my lord, and then that he was like,
Hearing music.
yes, music. But that's it when I try to see in the case diary, that part is, I didn't find.
That VDP.
Yes, going and yes, Ponia. Rubojyoti Ponia. He has not stated before the.
Not VDP, somebody else.
It-
6. Proposal 200, VDP secretary. He's 29.
I will not give much emphasis on PW1. He didn't have lordship relation, might not have so cordial. For 6-7 years, he did not visit his sister's residence. On being informed by PW3, he came, your lordship. He, along with his wife and his nephew, they came. And regarding his subsequent behavior, if your lordship considers regarding section 84, my lord, then I have submissions.
84, she has not made any submission.
Because calling police, etc., these doesn't show that this is covered by 850. His past contact also. I'm not.
Lordship, is extrajudicial confession before
See, if you fall back on 84, then the aspect of his commission of offense has to be in a manner admitted. Now, once it is admitted, the aspect of trying to conceal the body as well as the severed head in two different places, this will show that he was mentally agile. He wanted to conceal.
He wanted to hide.
defense tried to bring certain like suggestions were given regarding the land regarding the land not dispute, my lord. This witnesses
But
tried
why
to
there were no, even in this case, there were no bloodstained cloths. If you sever a head by an axe, by a kukri, there will be blood everywhere. It'll just go like a jet. If the neck is severed, you cannot just make the blood disappear. The assailant's own apparel would be stained. It was inside the house.
It was not seized.
Inside the house, there were other articles were not seen to be bloodstained. Even the floor, there was no bloodstain.
But he was saying, my lord, PW3, he was sweeping the floor.
Where? In 164, not in evidence.
But regarding that blood stain, one of the witnesses have deposed, my lord.
On the door.
Yes.
But it is not a matter of injury on a hand or a leg. Severing of the head. Just imagine how much blood.
Has to be flow, in fact, flow of blood.
And one factor, it's my duty to inform, duty to make it a point, your lordship, to inform this honorable court that PW3, he is the one who has seen throwing the garbage. But that thing, your lordship, that the victim has said, even if he cuts it, my lord, that accused person cuts her, then also she will remain there. Vis-a-vis that apprehension that he might have thrown the dead body.
No, that is a normal statement, which a mother makes. There was a commotion. Whatever my son does, I'll stay.
I'll say.
That has got nothing to do with the incident. Nobody can contemplate because of saying this. Actually, there'll be a incident of this nature.
That he will try to contemplate. I don't find anything except extrajudicial confession, that medical evidence, and the conduct.
Extrajudicial.
It was made, my lord.
All before the police. And he was, and there was assault on him. Even if you leave aside the aspect of police, then also it's not admissible.
Which kind of evidence, my lord?
No.
Presence of police, I think.
No, extrajudicial what? When it will be admissible? You have to read.
No, if this one not inimical relation, my lord.
Come to the Evidence Act. See, 25 or normally people go to 25.
Yes.
But what about 24? 24 is very important. 25 is something exceptional. 24 is the general law.
Yes.
Confession caused by inducement, threat, promise when irrelevant. Here he was bitten. He was sent to doctor. He was suffering injury. These are on record.
Let me see, my lord. the evidence.
Extrajudicial confession per se without there being a police will also not be admissible. It has to be proved
Yes.
that he made on its own
Yeah,
volition
volition.
without there being any threat, inducement, or promise.
Yes.
Otherwise, it will be hit by 24.
As per evidence of PW 4 and 6, your lordship, totally a presence of police was not there. 4 and 6. Four will go, but 6 it. Okay, as per evidence of PW 6.
You come to page 38. Page 38, the IO's evidence. Page 38, the last paragraph.
38. Before producing the accused in court, he was examined by doctor. As per report, doctor found injury. No, that is there, my lord.
No, please read.
In the requisition, Desmond Pierce is mentioned that the accused person had been badly assaulted by
Badly
local
assaulted
people.
by local people at the time he on your spot.
I produced the so and so, but I meant to, I have tried to substantiate a lordship. The PW 6, that time, police did not arrive. Subsequently, police arrived. Though at first, 6 line from the bottom, page 29, though at first the accused said nothing, but after some time he admitted that he had killed his mother. Then we informed the police.
Okay, we'll come back at 2 o'clock. You have almost completed.
Me, my lord, I'll be
Yes.
fine. Start.
Okay. Other matters, Mr. Bora, what is your matter? Let us see if time permits. Otherwise, criminal appeal will like to give some emphasis and finish the because.
Then your lordship may pick it.
Let us see.
Yes, my lord. Obviously.
The point out.
The kilo grinder. On the 6, 13 SCC,
2000.
6, 13 SCC, 65, Basu Prasad and others. On the state of Bihar. Para 24.
Listen.
Mahbub Khan versus State of Rajasthan, his court rejected similar contention of finding the first case had a postmortem before Sajil's death date had taken place exactly 24 hours before the postmortem was conducted. All that the postmortem reports say is the date had occurred within 24 hours prior to postmortem. Undoubtedly, the postmortem report was carried out at 11 a.m. 11 of 11/7/87. In other words, the postmortem report suggests that the date might have occurred immediately after 11/12 from 10/7/97. The contention asks for reference to textbooks from forensic medicine to show the time within which diabetes develops all over the body also has no factual disease. It depends on various factors such as suspicion of the disease, season of the year, temperature in the region, the conditions under which the body has been resolved. The record indicates that the body was taken from the mortuary. No, we notice that there is no cross-examination whatsoever. The doctor so as to elicit any of the material facts on which a possible argument could have been made. If there are the circumstances, then the presence of a rigor mortis all over the body by itself cannot warrant the argument of the learned counsel that the date must have occurred during the previous time. Acceptable ocular evidence cannot be dislodged on such hypothetical basis for which the proper ground will lay. Yet again, in Tanzania versus state of Tamil Nadu, this court observed, we have heard learned counsel and carefully looked into the material of the record. From the evidence of Peter to invite the doctor, we find that there is a possibility that the incident in question might have occurred about 35 hours prior to the postmortem. Though in the examination chief, PW5 has stated that the time between the date and postmortem could be 60 to 24 hours, which fits in with the prosecution case. In the cross-examination, he has very clearly stated that in this case, they would have been caused about 39 hours before the postmortem, which could be sometime after 5:30 p.m. on 15/12/19. This the doctor has stated by taking into consideration the time and the month of the incident, as also the time required for the setting of rigor mortis and passing of the same. According to the doctor, the month of December in a place like Tirol, the rigor mortis may occur about 2 to 3 hours after the date. He has stated that for the rigor mortis to reach from the leg to the head, it would take 12 hours and the snake would remain in existence for about 12 hours. Thereafter, it would gradually diminish in the reverse direction, that is from head to leg, taking about another 12 hours. And on this basis, when he examined the body of the deceased, he found the rigor mortis had reversed almost to the end of the day. By this process, he came to the conclusion that the date in question must have occurred about 39 hours before the postmortem. The incident took place in the winter season. The deceased was aged about 50 years. Rigor mortis thus would be well marked. Rigor mortis, as noticed here before, appears after 2 or 3 hours. It is well developed from head to foot in about 12 hours. The age, muscular condition, and activity before death, manner of death, and atmospheric conditions are relevant factors, so therefore we must find in various for the right. In our case, it was said with body to lay the doctor opined. Another suggestion I feel like to remove part of the engagement.
Regarding
Remove part of that 106 part. 2006 LS66.
2006,
LS6681.
paragraph
Paragraph 12,
12.
12, 14.
Regarding what?
They used to be already stated in somewhere.
106 of the Evidence Act. Special knowledge.
Although the landed trial could not prove, but the figures could not prove insanity part. But the lordship, it is acquitted manner. And if the lordship, I think have a move. Accused person appeared to sound mind. Judgment and acquittal are done on foundation mind.
No, we are not going
No,
into.
335, 335 CRPC.
Yes. Yes.
Person acquitted on such ground to be given if his lordship, although lordship has not hold that he is insane, but lordship, since he could not prove himself. that
No,
he was-
if we, the acquittal is on the ground of general exception under chapter 4, then has to be, he has to be declared as an insane person who comes in the ambit of 84.
That's true.
84. That has not even been argued.
Not argued, but still, your lordship, his, mental status being judged by the, by the jail authorities. Because 329 says, my lord, person accused of such ground will be detained in safe custody because it may be injurious for the society, my lord, because his conduct was not the normal.
This will be counterproductive, madam. If you are admitting that he is insane, he comes under 84, then he gets the benefit of general exception.
That's
He's-
true, your lordship,
that is not-
he's
that-
acquitted.
No, then acquittal, if you say that he is acquitted, he is mentally insane, then he'll get automatic benefit.
Your lordship, what I meant to say,
No, you cannot make this argument.
what I
This is
meant,
bit-
your lordship, because his conduct.
Madam,
is,
just think over it, what you are arguing. You are arguing against yourself.
No.
You are
lordship, because
saying-
he's,
No, you are,
mental part.
you are
even
what,
Otherwise, while he's a drug addict person.
that
because
will,
basically.
that will not,
exhibited.
that will not come into operation. If you bring in the insanity into operation, that is only 84. And if you say that if he is acquitted and he is medically insane, then he should be held in custody. If you are admitting to that, then
At least DPP lordship, that observation we made that he may get the rehab. Because his conduct, whatever medical documents and it was exhibited in the London trials of England. And from the mouth of the witnesses have come up, his conduct was not good, my lord.
please understand before you make a submission.
And not.
Don't read 335 in isolation. Read with the previous section. What is the previous
Yes,
section?
my lord, Jasmine and to underground.
On the ground of answerness of now.
I am arguing
No,
that is bad.
the 335 will only come when 334 judgment has been passed.
I'm not relying on 335. In general perception, Lordship, I'm making the submission. Since the conduct of the accused appellant from the mouth of the witnesses have come up, that it was not that was a normal one, my lord. I'm not saying it's abnormal, but his behavior and his actions were not good, your lordship. So before lordship, at least he will be kept in like rehabilitation, my lord. If his conduct in the jail is not good. I'm not saying he's insane, my lord.
This argument will not come. Which chapter 25, all these provisions are part of chapter 25.
Listen, my lord.
Please, what is the provision of chapter 25
Chapter 25.
of the CRPC?
Yes.
These are provisions to an accused person of answer now. Now,
No, I will not be relying on any of the
so
provisions.
this will not come into operation if only a judgment is passed based on the general exception of chapter 4 of the IPC, giving benefit of 84, then these may come into operation.
I'm relying on that, your lordship, since from the mouth of the witnesses that come up, his conduct is already used to take drugs and all, my lord. Before 2 days also used to take, people used to consume drugs and cannabis, my lord.
Where?
Yes.
Will it make him an insane person?
No,
Then,
I'm not saying, my lord, if he's released, my lord, at least this.
if he's taking drugs, will not be an insane person. Let us see where.
Lordship.
Taking drugs those are not part of us. We are not to deal with those matters. Yes,
Exhibit B60,
page
history sheet, 149.
140. Yes.
Down below, last paragraph. Was maintaining well in six fact which is mother notating to be talking more than usual. He was talking relevant, however. Then he went to.
Page 1.
Phase 150.
Yes.
Then he went to shop and started giving tips to customers for pay. It's a case he had taken Ganza 150 before that. Who they stated behaving oddly came and asked his mother to go out.
February 12. Yes, okay.
Then page 160.
168.
Down below, HOPI, I don't understand people, so please informant. The patient is cannabis and alcoholic abuse from last time.
Okay.
The PWC has not seen him carrying the dead body, etc. Only seen the garbage, etc. If we go on with evidence also not. But for a person, whether it is how much it is usable to carry a dead body and so all those things single-handedly. And have you seen at that time also there should have been blood stain because we had seen it immediately. Perhaps if we take this evidence seriously also not then also he had thrown the dead body, that body part. Then he had garbage at that moment possibly he has no time to even wash if we go. Later he had washed it also.
No, there is one catch here.
Raining.
No, raining was at the night. So if it was raining at the night, then you may possibly argue that how does he go for a morning walk in the rain? He goes for the morning walk at 4 o'clock. 4 o'clock, he doesn't see him dumping the body. 4 o'clock, he sees dumping some garbage. So whatever has been done was done during the night when it was raining. So the explanation automatically comes, it was raining heavily. So the blood stain, lack of blood stain on the way. So that becomes
At least at the veranda, etc.
veranda, it was seen washing.
So if he had washed it, then whether he had washed it or not, if it is wet, then only they can say that it is washed.
No, it was washed at 4 o'clock.
But people came later on.
Later on, later on there will not be wet, but you may point out one thing, the washing thing was not in the evidence.
Yes.
It is only in 164.
And that early writer part of the mother, that is also only in the, that is not in 164. That early writer part is only in the later at the time of evidence. That what would be the first impression that where is your mother? But he had not, he had presumed that he had killed, he had done something. Yeah, possibly may not be the first presumption.
Amicus. Leave again. Hearing is not closed. Okay, we'll consider. Where is Mr. Bora? Bora said there is some matter.
Oh, yes.
The matrimonial can wait. Criminal appeal are more important. 2020 case. Matrimonial of which year?
Here there was a quarrel between the accused and the deceased, and the accused gave a information. There is not the constitutional.
They are related.
Not really. That's regarding.
No. PW1 witnesses are related. No. This is then the appellant. Related? No. I think we have heard two matters. We two mixing up of facts. We'll try to have a civil matter for a change. Yes, Mr. Bora, what is this? But Mr. Gupta, wait for a while. Let us see. Let us freshen up our mind.
Let's take a look. My lord, is an appeal against the,
You are paying for divorce.
yes, my lord. The decree for divorce. Yes, my lord.
Your ground for desertion and cruelty.
Yes, my lord.
Both have been rejected.
Yes, my lord. And
You said that two of the witnesses' evidence were not considered.
yes. I tell you,
When was the marriage? Gupta.
Item 4.
How many?
11 witnesses.
Let's try. For some time. Therefore, we are asking whether they are related. Two cases.
We have been only hearing about the mother.
Son killing mother, brother killing brother.
The accused are brothers, but one got accused, no?
One got it.
And one got accused. There were 2 persons who were charged.
Usually case of the circumstantial evidence, my lord, but the principle which is applicable, my lord, in case to base a conviction solely on circumstantial evidence, those constants, my lord, which is laid down in this case, that has not is not fulfilled in this case. Change is not there. Case of the conviction, my lord, page 4 is the
Just a minute. The allegation is assault by what?
served by Iron Rod.
Iron Rod.
Yes. The medical reports were revealed that yes, the death is caused by previous injury on the head.
Blunt weapon.
Blunt.
Clear some other dates then, okay? Sister has some single bench matters. And we'll try to concentrate on the judgment, okay? Let's. If there is no urgency, we come on its own, otherwise. Did. You give a date of your convenience. Oh, yes, that is enough.